Doesn't sound right the way you say it, Justice Kennedy.
But you don't want them to say either that there's a death spiral. You don't want us to make either of those two findings, I'm assuming.
That's correct. No, I agree that there's a risk. The significance of it, people can debate. But what I think is lost in that question, and I didn't mean to be whimsical about it, I think what is lost in a little bit is what's on the other side, which is the fact that if you follow the government's suggestion, if the court follows the government's suggestion, what is going to be lost is something we know is a central part of the Act. I mean, indeed, if one sort of looks at the legislative history more broadly, I think much of it is directed toward the idea that guaranteed issue and community rating were the crown jewel of the Act. The minimum coverage provision wasn't something that everybody was bragging about. It was something that was meant to be part of this package. I agree with that. But the point of it was to have guaranteed issue and minimum coverage. Guaranteed issue and community rating. And that's, under the government's proposal, those would disappear. We would go back to the old system. And under what I think is the proper severability analysis, the real question the court is asking, should be asking, is would Congress rather go back to the old system than to take perhaps the risk that you're talking about, Justice Kennedy?
You're referring to the government's second position. Their first, of course, is that we shouldn't address this issue at all.
That's correct.
I asked Mr. Kneedler about what procedure or process would be anticipated for people who are affected by the change in the law and the change in the economic consequences. Do you have a view on how that could be played out? It does seem to me that if we accept your position, there has to be a broad range of consequences, whether it's additional legislation, additional litigation. Any thoughts on how that's going to play out?
Well, if the court adopts the position that I'm advocating, Mr. Chief Justice, I think what would happen is that the court would say that the minimum coverage provision, by hypothesis, of course, is unconstitutional, and the fact of that being unconstitutional does not mean the invalidation of any other provision. So under the position I'm advocating, there would no longer be challenges to the remaining part of the Act.
But if the challenge is what we're questioning today, whether if you're an insurance company and you don't believe that you can give the coverage in the way Congress mandated it without the individual mandate, what type of action do you bring in court?
If the court follows the course that I'm advocating, you do not bring an action in court. You go to Congress and you seek a change from Congress to say the minimum coverage provision has been struck down by the court. Here's the information that we have to show you what the risks are going to be. Here are the adjustments you need to make. One of the questions earlier pointed out that states have adjusted their systems as they've gone along, as they've seen things work or not work. You know, I was talking earlier about the different ratio for ages in the insurance. The states have tended to change that because they found that having too narrow a band worked against the effectiveness of their programs. But they didn't, except for Massachusetts, they didn't enact mandates. So I think to answer your question directly, Mr. Chief Justice, the position I'm advocating would simply have those pleas go to Congress, not in court. Now, if one, just to discuss the issue more generally, if that's helpful, I think that if there were situations where the court deferred, let's say, for discretionary reasons, the court said we're not going to take up the question of severability and therefore not resolve it in other situations. It certainly seems to me that in enforcement actions, for example, if the time comes in 2014 and somebody applies to an insurance company for a policy and the insurance company says, well, we're not going to issue a policy. We don't think your risks are ones that we're willing to cover. It seems to me that they could sue the insurance company and the insurance company could raise as a defense that this provision, the guaranteed issue provision of the statute, is not enforceable because it was inseverable from the decision, from the provision that the court held unconstitutional in 2012.
Let's consider how your approach, severing as little as possible, thereby increases the deference that we're showing to Congress. It seems to me it puts Congress in this position. This act is still in full effect. There is going to be this deficit that used to be made up by the mandatory coverage provision. All of that money has to come from somewhere. You can't repeal the rest of the act because you're not going to get 60 votes in the Senate to repeal the rest. It's not a matter of enacting a new act. You've got to get 60 votes to repeal it. So the rest of the act is going to be the law. So you're just put to the choice of, I guess, bankrupting insurance companies and the whole system comes tumbling down, or else enacting a federal subsidy program to the insurance companies, which is what the insurance companies would like, I'm sure. You really think that that is somehow showing deference to Congress and respecting the democratic process? It seems to me it's a gross distortion of it.
Well, Your Honor, the difficulty is that it seems to me the other possibility is for the court to make choices particularly based on what it expects the difficulties of Congress altering the legislation after a court ruling would be. I'm not aware of any severability decision that has ever looked at anything
that wouldn't be my approach. My approach would say if you take the heart out of the statute's gone. That enables Congress to do what it wants in the usual fashion, and it doesn't inject us into the process of saying this is good, this is bad, this is good, this is bad. Seems to me it reduces our options the most and increases Congress's the most.
I guess to some extent I have to quarrel with the premise, Justice Scalia, because at least the position that I'm advocating today, under which the court would only take out the minimum coverage provision, I don't think would fit the description that you have given of taking out the heart of the statute. Now, I do think once you take out guaranteed issue and community rating, you're getting closer to the heart of the statute. And one of the difficulties, I think, with the government's position is that I think it's harder to cabin that, to draw that bright line around it. It's harder than the government thinks it is. I mean, to begin with, even the government seems to acknowledge, I think, that the exchanges are going to be relatively pale relatives of the exchanges as they're intended to be, where you're going to have standardized products. Everybody can come and make comparisons based on products that look more or less the same. But the other thing that's going to happen is with the subsidy program. The way that the subsidy program is set up, the subsidy is calculated according to essentially a benchmark plan. And if the court wants to look at the provisions, they begin at page 64A of the private plaintiff's brief, again in the appendix. The particular provision I'm talking about is at 68A. But there's a question. You're looking essentially to calculate the premium by looking at a standardized silver plan. First question, obviously, is there going to be any such plan if you don't have guaranteed issue and community rating, if the plans can basically be individualized? But the second problem is that in the provision on 68A, the provision that's used for calculating the subsidy, what is anticipated in the provision under the Act as it is now is that you have the floor of the income. You would take this benchmark plan, and the government would pay the difference. And as we talked about earlier, the benchmark plan can change for age, and the provision says it can be adjusted only for age. So if, in fact, you even have such a thing as a benchmark plan anymore, if the rates of people in poor health go up because of individual insurance underwriting, the government subsidy is not going to pay for that.
Mr. Farr, I understood that the answer that you gave to Justice Scalia was essentially that the minimum coverage provision was not the heart of the Act. Instead, the minimum coverage provision was a tool to make the non-discrimination provisions, community rating, guaranteed issue, work. So if you assume that all the minimum coverage is a tool to make those provisions work, then I guess I would refocus Justice Scalia's question and say, if we know that something is just a tool to make other provisions work, shouldn't that be the case in which those other provisions are severed along with the tool?
No, I don't think so, because there are many other tools to make the same things work. That's, I think, the point. And if the case that comes to mind is New York versus the United States, where the court struck down the take title provision, but left two other incentives essentially in place. Even without the minimum coverage provision, there will be a lot of other incentives still to bring younger people into the market and to keep them in the market. And if my reading of the finding is correct, and that's all that Congress is saying, that this would be useful, it doesn't mean that it's impossible to have a...
I'd just like to hear, before you leave, your argument, if you want to, against what Justice Scalia just said. Now, let's assume, contrary to what you want, that the government's position is accepted by the majority of this Court. And so we now are rid, quote, of the two heart of the bill. Now, still, there are a lot of other provisions here, like the Indian Act, the black lung disease, the wellness program, the restaurants have to have a calorie count of major menus, etc. Now, some of them cost money, and some of them don't. And there are loads of them. Now, what is your argument that just because the heart of the bill is gone, that has nothing to do with the validity of these other provisions, both those that cost money or at least those that cost no money? You want to make an argument in that respect, that destroying the heart of the bill does not blow up the entire bill. It blows up the heart of the bill. And I'd just like to hear what you have to say about that.
Well, Justice Breyer, I think what I would say is if one goes back to what I think is the proper severability standard and say, would Congress rather have no bill as opposed to the bill with whatever is severed from it? It seems to me when you're talking about provisions that don't have anything to do with the minimum coverage provision, there's no reason to answer that question as any other way than yes, Congress would want these provisions.
The real Congress or a hypothetical Congress?
An objective Congress.
Right. Have you come across
not specific, not with a vote counting.
Why put Congress to that false choice?
Because,
you only have two choices, Congress. You have the whole bill, or you can have you can have parts of the bill or no bill at all. Why that false choice?
I think the reason is because severability is by necessity a blunt tool. The court doesn't have, even if it had the inclination, doesn't essentially have the authority to retool the statute.
Yeah. Well, and also, I would say stay out of politics. That's for Congress, not us. But
right.
the question here is, you've read all these cases, or dozens. Have you ever found a severability case where the court ever said, well, the heart of the thing is gone, and therefore we strike down these other provisions that have nothing to do with it, which could stand on their feet independently and can be funded separately or don't require money at all?
I think the accurate answer would be I'm not aware of a modern case that says that. I think there probably are cases in the 20s and 30s that would be more like that. If I could just take 1 second to address the Economist brief, because Justice Alito raised it earlier. I just want to make one simple point. Leaving aside the whole balancing thing, if one looks at the Economist brief, I think it's very important to note that when they're talking about one side of the balance, may I finish?
Certainly.